Human rights group Jamaicans for Justice is calling for immediate government action, with children still being locked up for being, quote, uncontrollable. This despite laws passed to end the practice. As Carla MD now reports, the group insists this is not in keeping with the Conventions on Rights of the Child.
2 years after the Child Care and Protection Amendment Act was passed into law, but it is still not in force. As a result, hundreds of children continue to be brought before the courts instead of receiving support through the Child Diversion Program or community-based interventions, a major concern for human rights watchdog Jamaicans for Justice.
It is intolerable that we still have children who are being incarcerated for behavioral issues that are not criminal offenses. So in other words, you have a child who perhaps ran away from home, a child who is not going to school, that would need necessary intervention, could find themselves being placed in a juvenile detention facility. This heavy reliance on the courts for behavioral interventions, not only does it divert from good resources, because these things could and should be decriminalized, what it means is that our children are being brought before an adversarial court system where early diversion should be the first resort. So, for example, if a child has behavioral challenges, we would want the police to first divert that child so that the child does not have to interact with the courts to benefit from the child diversion program.
JFJ is offering legal assistance to review the cases of children in custody and those who have turned 18, aiming to secure appropriate releases or court-ordered interventions. The group is also requesting urgent talks with the Ministry of Education and the Child Protection and Family Services Agency to ensure the law is applied properly.
We believe that it is in the interest of justice that you pause and get rid of the act that currently allows for children to continue to be criminalized. And JFJ, we have offered our legal support to the government so that children who are currently in the custody of the state on the basis of being uncontrollable, they can be brought before the courts. The courts can look on their matters on a case-by-case basis, and the courts could then vary the orders so that those children, where appropriate, could be released to their families and they can benefit from necessary psychotherapy interventions so that we can see improved behaviors and these children can get the necessary support.
JFJ warns that continued detention of children under this outdated law is a serious concern and says urgent action is needed to protect their rights.
We are calling on the government to bring into full force the amendment that was passed no later than January 31, 2026, to prevent further criminalization of children who have committed no criminal offense. Because if we understand collectively that we want to rehabilitate and not institutionalize our children, then fewer children would need to benefit from facilities. And while we appreciate that these facilities that the minister alluded to would need to be fit for purpose, again, the intent of the legislation is that children who are in need of the protection and the care of the state, they should benefit from psychotherapy that they could do so from the non-residential facilities.
Carla MD, CVM News.